Good morning, everybody. It's nice to see you on this Wednesday morning. We are going to call the October 14th Social Responsibility Work Group meeting to order. I guess we'll go to the first item, which is remarks from me, which aren't very many, but we do have a new member, Bob Baker, who was on the Broker Responsibility Working Group last time, has joined us in replacing Bob Jacobs. So it's not going to be hard to remember their names because it's two Bobs. But Bob, new Bob, do you want to introduce yourself?
Okay, thank you. I'm very excited to be part of this group. I went ahead and went through the video. Thank you, Vanessa, for sending me that for the last two meetings. So I learned an awful lot about this group. It's a great group to be part of. I'm a broker in the Collin County area. I have two offices, about 600 agents. I had a broker's license for 53 years, so I've got a little different perspective about all this. But I am more excited today in the direction of real estate. It's better than it's ever been, more challenging, but the things that we have in front of us and the things that groups like this can help the industry is just incredible opportunities. And I'm very pleased to have a little part in it. And thank you for allowing me to be part of it. And I appreciate it and I look forward to it. Thank you.
Thank you. Okay. The next item is discussion and possible action to amend the September 9th meeting minutes. Do we have any questions? Has it been reviewed and approved? No. Okay.
Brian approved them from my recollection, unless I'm remembering wrong.
You do not. Was that Pam? Was that Pam just now?
No, that was Amber. That was Amber. I just said that Brian had approved them.
Oh, okay, perfect. I didn't hear you. I'm sorry. I think Vanessa may have a couple housekeeping items to go over. So let's back up and go to Vanessa.
Sure. Yeah. So if nobody else has any, they were approved. If nobody else has any comments on those minutes, then we're good on the minutes. I just wanted to cover a couple of technical things with everybody that we do every time because there's time between meetings and people forget. One is to mute if you are not speaking. That cuts out with that helps us with the background noise. Sometimes we'll go in and mute people if they haven't done it. We can't unmute you though, so always check to make sure you unmute before you start speaking, though we'll typically let you know. Two, you have that raise hand function on your toolbar. That's a great way to let people know you want to speak on something. You can always speak on something, but sometimes a lot of people start talking and using that raise hand function is really helpful, and then the chair can call on you. Three is that at the end of this meeting, make sure you hang up and close out. We do record these meetings, so we just want to make sure everybody actually leaves the meeting. And I think that's it. That's just, oh, the chat. The chat function is another one. We try not to use that for open meetings purposes. You can use it if you're having issues, like if you're having technical issues, you can't hear, you're speaking and no one's hearing you, things like that. Please feel free to use it. On occasion, if someone's really having issues, they'll type stuff in and then the chair can read it into the record. But generally speaking, we want to stay out of chat for open meetings purposes. Additionally, we have extra recording requirements during COVID-19, and we really can't record the chat. So that's it. Nothing super exciting, just the basic housekeeping with Microsoft Teams. Thanks.
There's one other thing that we just talked about. When we're doing comments today, since we do have such a long day and a long agenda, let's try to keep our comments to 5 minutes. And if you've already said something for a previous item and you want to reiterate it, just say, I'm reiterating whatever. so we don't have to go through the same thing over and over again. So I hope we can do that. Are there any public comments on a non-agenda item?
We don't have anybody signed up.
Okay, perfect. I guess we're open for new business now, and the first item is discussion and possible recommendation regarding education and experience requirements for an individual real estate broker license. The staff has drawn this up per our recommendations, and we have already voted upon it, so there's not going to be that much discussion because I don't think there should be any changes. What we were doing is trying to balance the education and experience requirements so we could hopefully meet the governor's orders and get something passed through in January. So does the staff want to go over that?
Yeah, we can. Hold on one second. I'm going to pull it up, which I have up. I have 1,000 windows up. Okay, so I will say what you guys voted on was 636 hours total. It was 270 of qualifying courses, including real estate brokerage, and 366 hours of real estate related courses, with 6 hours being that broker responsibility course, and then 4 years active experience in the last 5 years for a total of 7,200 experience points. And I can share my screen. Denise just pointed out that I'm not. Hold on. Oh gosh, I don't want you guys to see how many windows I have open. Okay. I'm stealing this from something that Denise is going to share later, by the way. So the only, and this is something I literally just sent Leslie an email on this. This is the way that this is written is at 630 and 360. If you look, I'll highlight it. And that is simply due to the fact that we've had as staff sort of a last minute conversation on, can we require that broker responsibility course, that 6-hour course, since it's typically a CE course, and one that they'll likely, not everyone, but likely a lot of them will have to take as required CE. That is something that, with your discretion, we can work with the chair on in getting the final recommendation that she takes to the commission. But we just wanted to note, we haven't fully digested this. I think with education and experience, you guys, every turn you make, you run into like 7 new layers of, well, how does it work with this? How does it follow with this? So we have your proposed recommendation as 636 with the 366 hours and the required broker responsibility course. There is a chance that it makes more sense to pull that broker responsibility course and leave it in CE and not as a qualifying requirement. We just want to give you the heads up on that because your recommendation could look different. I don't know that it will. Later on in the agenda, there's an item where we'll recommend delegation to the chair to work on the final recommendation and presentation to the commission. And that's where sort of in the interim between this meeting and the commission meeting, we can work with Leslie on getting the language solidified. I don't see any other real changes other than this, but I think it'd be wrong to not give you the heads up that once we've digested a little bit more, it might make more sense to pull that broker responsibility course from the qualifying requirements. Does that make sense? And Denise or Tony, if I said that poorly, please chime in.
Well, this is Jennifer, but I think that you did say that appropriately. I think that in the previous conversations, there may have been a little confusion because we were discussing for the real estate brokerage course, the 30-hour real estate brokerage course. And then there was also mention of the 6-hour broker responsibility course. So just to reiterate, 30-hour real estate brokerage course is still part of the recommended requirement. The only variable is whether or not that 6-hour CE course can be part of the pre-licensing requirement.
Well, and
Right.
this is Tony, if I may. I mean, obviously the recommendation can include that. I think the concern or the issue on staff's part is that course is designed to be a CE course, so it's focused on teaching people who are already in the business to a certain extent. Qualifying course has a different focus, which is to get people up to speed on how to operate in the business. As well as it being a mandated CE course, it's something that someone would have to take within the next 2 years after they get licensed as a broker anyway. So it's just whether or not it makes sense because of the focus of that course being a continuing education course and not even one that all brokers have to take. It's focused on what the responsibilities are in terms of when you sponsor somebody as well. So just that's where that kind of conversation happened on the staff level.
But that, this is Vanessa again. So that doesn't mean to change your recommendation at all. And you voted on it and we've got it. It just means, does there end up being an adjustment to that once you've delegated a little bit to the chair? Maybe, maybe not. But it's, I think it's something that you know, we can kind of hammer out post this meeting that isn't, I don't think, unless you all do, and you're welcome to discuss this, of course, is a huge disruption to what your actual recommendation is. Because the way I see your recommendation is you're saying, okay, we're going to cut back on education, but we're going to increase experience, because experience, I think, as we all know, is where you really learn how to do your job. At least it has been for me, and I assume for most people, right? Classes teach you a lot. They do, but I think what I've seen out of this group is, hey, let's get some experience in there. Let's get some real world stuff in there and increase that. And you'll still be making that even minus that one class, you're making that recommendation. That seems to be the real strength of the recommendation itself. So I don't think cutting the 6 hours necessarily throws it all off base. You guys are welcome to disagree. And I'll turn it back to Leslie, but I just wanted to give you that heads up because I would never want you to think, oh, you guys recommended this thing and then we came in and, you know, had this whole other idea that we never told you about, because I would never want that to be the case.
This is Tucker. I agree with you 100%. The crux of what we're changing is exactly what you just said. And so if we have to lose the 6 hours, then they're going to get the 6 hours every 2 years anyway. So that's fine.
Okay, guys, make sure that we raise our hands, because I think somebody was getting walked over because Brian had put his hand up. So Brian, did you have your hand up a minute ago?
Yes, I just wanted to ask the question if the content of the 6-hour broker responsibility course is covered in the qualifying courses, like the brokerage course.
It is not.
I can answer that. It is not, no.
And that is why I think the 6 hours should stay, because if it's somebody who's going to get their license, the 6-hour broker responsibility class is applicable real world current issues in real estate brokerage, where that 30-hour promulgated class hasn't been updated in God knows how long. And
correct.
So the fact that the broker responsibility course is updated every 2 years, it's current, the stories are current, the cases are current, everything that is, you know, I teach that class. Everything's up to date, and I think that that's super valuable, for whatever that's worth.
This is Jennifer. I'll just add that the last time the 30-hour real estate brokerage course was revised was in 2016.
We're all good with this to move on, and then I'll meet with staff and figure it out before it goes to the commission. Okay, perfect. Moving on to number 7. Discussion and possible recommendation regarding license of out-of-state military spouses transferred to Texas. There are some parts of this that probably don't need any tweaking and that we don't need to even discuss, meaning expedited applications, waiver of fees and requirements. We're really focusing on the substantially equivalent, the waiving of other requirements, and the credit for military service and limited reciprocity for military spouses. I don't know if Amber or Vanessa has the slides to kind of walk us through this.
The summary, Leslie?
The slides that I sent the other day, for the most part, just
Okay,
through this.
I have it.
I think I sent Vanessa an updated one yesterday.
Amber
Yes,
should
that's-
have that.
Yes, I have it. 1 second.
Okay, perfect. So right now, the rule says if the applicant holds a current certificate or license issued by a country, territory, or state other than Texas that has licensing requirements that are substantially equivalent to the requirements for their certificate or license issued in Texas, the commission shall issue the license as soon as practicable after receipt of the application. As we learned in the last meeting, we're really not substantially equivalent to anybody. So we're not really having anybody get a license going this route. We asked you, what does substantially equivalent mean to you? For the most part, some people said there's zero deduction or other. So if we go down to, I'm just trying to go through the things. Who's doing the screen? Vanessa?
Amber is. You can, if you want me to go down to the next page, I can.
I'm just kind of showing everybody exactly what was done and how we got there. And then we'll summarize. So as you see on this screen too, a lot of us agree that people should become sales agents prior to becoming a broker. And then they also should be sponsored and mentored by a Texas broker. I also listed the comments, and we can send these out later if anybody wants them. If we go to the conclusions page, Amber, I've summed it all up here. It's slide number 5. Okay, there we are. So the majority do not agree that there's a 40 to 60% deduction in licensing requirements. We believe there should not be a deduction at all or something other than that 40 to 60%. If the out-of-state applicant doesn't have the education and experience requirement to become a broker, then the applicant can apply as an agent until the requirements are met. If they have those, if they're qualified to be an agent. An out-of-state broker applicant should have to be sponsored and mentored by a Texas broker for the first 6 months to a year. We were split on 6 months and a year. All applicants should be required to take Texas promulgated contract prior to receiving a license, and broker applicants should also complete the broker responsibility course. If not required upon initial licensure, the applicant could have 2 months to complete the required course. All applicants should have to take the state exam prior to licensure, and applicants should not have to take the national exam. So before, I'm going to go to what the staff has recommended in just a second, but we had also written to consider, instead of using percentage deduction to qualify as substantially equivalent, an education waiver could be offered for verifiable classes that have been taken and can be counted toward the requirement. Or an out-of-state applicant could be issued a temporary provisional license for 6 months, allowing them to complete all required classes to obtain a broker's license. The experience points must be accumulated. A broker's license will be once education and experience requirements are met. An applicant should not have to take the national exam if from a state that participates in the national exam accreditation with a RELO. From what I've learned this morning, that we have to issue a license and it can't be temporary. So I want to go over to staff and let them kind of give their take on it and what their recommendation is.
Yeah, hey everybody. So I'm gonna turn this over to the real expert, which is Denise, probably with some tag team from Tony. But I think that Leslie brings up a good point. This is hard because I think all of these are good points. I will tell you that we are bound as a licensing agency by statute. And the statute is already out there and the agency has already adopted a rule, which means the commission has weighed in that mirrors that statute. So if you, I'm gonna actually, Denise, is it okay if I share my screen real quick? Thanks.
Sure.
Thank you. So we've got this recognition of out-of-state military spouse. And what this is saying is that somebody who meets the definition of substantially equivalent, which is what we're trying to get to, that's what this group is really focused on, like Leslie said, we will recognize that license. We've been given that directive. Recognition of an out-of-state license of a military spouse. And let's not forget, this is a small group, right? And the goal behind this is, hey, we've got folks that are serving our country that are being sent to Texas along with their spouses and their families, and we need to figure out a way to help them work, which I think is a great thing. But the reality is, once they meet that substantially equivalent requirement, we don't get to do much, right? We have to recognize that out-of-state military spouse, that out-of-state license. There's a process that they have to go through, and you'll see that here. They have to notify us, they have to submit proof, we have to provide confirmation. At the moment, we can't confirm anyone because this agency's interpretation of substantially equivalent has basically been the same, and since Texas has so much, so many requirements, it's hard to, or it's impossible to meet. So we want to get a substantially equivalent definition that really goes to the spirit of this statute, that allows for these spouses to be able to come in. It's not forever. It's a small group of people, but it really is recognition of that out-of-state license and saying, hey, this person's coming from Oklahoma and they have this experience, and it is something that we deem substantially equivalent. So I think it's important to remember that framework here, that it's a small group. We have certain requirements. We're bound by statute, and you'll hear Tony and me kind of keep weighing in on what the statute says, because that's where we have to go, the statute and the rule. And let me see, I think I have our rule pulled up here. Yeah, told you guys I had a lot of windows. Can you see this? Can you see the rule now? 535.58. Yes, anyone? Okay, all right, sorry, I can only see Leslie's face because I've got my screen shared. She doesn't have her head. So that's where we stand. I'm going to turn it back over to Denise, who I think can give us a little bit of framework. She's going to show that staff recommendation again. I think, you know, we talked about these required courses, and Tony and I had a long conversation about this yesterday. I think that's a way of hopefully getting to substantial equivalent that meets our goal of getting a substantial equivalent definition that's real and that can actually, people can meet, but also address the concerns of this group, which is, hey, we need people to know about Texas. And with that, I'm going to turn it over to Denise. I see that Tony and I think Chance have their hands raised. Tony, do you need to follow up on what I said?
Well, I don't want to speak before a committee member. So if Chance wants to speak, then I can follow up on what you said.
I just had a really quick clarifying question for Vanessa or Denise. What was previously shown on there, the code that you pulled up, where is that? Is that, I saw there was a track rule, and then is the other one, is that occupations code, or where is it?
It's Chapter 55 of the occupations code.
So that's for all licensing agencies, and the rule is the TREC rule.
So the only thing I wanted to just reiterate was something that Vanessa said about the sort of population that this applies to. So it's military, this particular statute and rule applies only to military spouses. There's the substantially equivalent thing, but also the statute caps it at 3 years. So under this provision, a military spouse can only be licensed for up to 3 years. The way our rule is written is I just had it up. I think it's the lesser of, the lesser of the time in which they're stationed in Texas, or 3 years, but it's also tied to their license in another state. So if their license is an annual license, they have to come back to us every year and get recertified to be under this for up to 3 years. So there are things in place that, that, you know, this isn't sort of the Wild West, someone coming in and being able to do something. It's focused on a limited population for a limited amount of time for people who have been stationed in, you know, or stationed in Texas, you know, serving in Fort Hood or someplace like that, and their spouse is licensed in another state to allow them to work while they're here and bring in that income. So I just wanted to just put that out so that you have kind of the full universe of what this applies to. I'm done.
Thanks. Does the staff want to go over their recommendation?
Yes, this is Denise Sample, the Director of Licensing, and the staff recommendation, you know, we took kind of the discussions that were happening in the earlier meetings and came up with, you know, compared it to the proposed recommendations for just the regular broker license requirements, and came up with the staff recommendation here for a broker license, which is to require 50% of the number of hours of education and 50% of the experience requirements, plus completion of 4 30-hour qualifying courses, you know, after discussion with Jen, weighing in on which ones we thought would get them that Texas education. So promulgated contract forms, law of contracts, law of agency, and real estate brokerage. And this, you know, we used that wonderful spreadsheet that Leslie crafted that had all of the requirements for the different states, so you could see what kind of requirements they had and what they might be lacking, what they might need to come to Texas. So when we compare that to the current requirements, it gets them to about 63% of the current education hours. Compared to the proposed requirements that you guys have come up with, that requirement would get them to 89% of the hours that we require. And it would still require them to take those, you know, 4 courses that we've, you know, decided are pretty important to come and practice in Texas. We also moved toward, you know, the sales agent license to define substantially equivalent. It's going to be helpful for any of those applicants, whether they're applying for a broker license or a sales agent license. So we also made a recommendation to require 50% of the number of hours for a sales agent license, plus 3 specific 30-hour qualifying courses, which are promulgated contract forms, law of agency, and law of contracts. That would get that military spouse applicant to 100% of the number of hours required to apply under the normal process for a sales agent license in Texas. You know, we're really hoping that defining substantially equivalent is going to be a real big help to those military spouses who, you know, once we define it, we can put that on our website. We'll be able to get that information out to them, so when they get those transfer orders that they're getting, you know, shipped to Texas, they'll be able to go to our website and start signing up for the classes that they know for sure they're going to have to take. And I'm happy to answer any questions. If I missed anything or skipped over something, let me know.
Bill, do you have a question?
My issue is that what we're talking about is, I think, going to roll into very quickly our discussion about reciprocity generally. And so that the information that we do here with the military spouses is really going to be very similar, or we're going to have similar discussions with regard to reciprocity. And I'm as much as I want it to be more loose and easier on our recommendation for folks that are in Texas getting their licenses, I'm sort of coming on to the other side of being a little bit more tougher on folks that are coming from outside and don't really have the education requirements. So I'm supporting what the staff is suggesting on the educational requirement for the classroom, the specific courses. And I think maybe what the issue should be is giving them the experience, coverage because they've got a previous license. But I'm a little bit concerned as to, and I understand there's a statute, but I really don't quite understand what the difference is between a military spouse coming into town and somebody else coming into town. And I understand, I really do understand the need to accommodate military spouses, et cetera. But in the broader picture of providing reciprocity to people coming in from out of state, I think this is really an important question. And I don't think it should be that easy. I don't think they should be able to get a broker's license, even if they have a broker's license in another state. I think there should be a requirement that they serve as, if we're going to allow them to practice, they have to be in an agency relationship where they are mentored, where they do have supervision. And I think the limited time period is the right approach. I think, again, I'm struggling with how to frame the outline of it, but those are some issues that I'd really like to get some feedback from other folks to see if there's any concern about that from anybody else.
Thank you. Tony, you want to chime in?
I don't want to talk over anyone on the committee. I'm happy to address a couple of things Bill said. One is, I understand that you understand what the difference is, but a significant difference is this is limited to a 3-year time period. It's not reciprocity. It's not getting a license and then you're good to go for the rest of your career in Texas. And likely those individuals may move on if their spouse is stationed someplace else. The other thing is, and this is not to complicate things, but there's nothing that says that you can't define substantially equivalent to mean different things for different portions of populations. You could say for this particular provision for military spouse, it means this. For other people coming into the state, it means this. Just in order to get to the kind of the spirit of what this is, as well as the directive of the governor's office that we need to work on being a little bit more open to helping, vets and active military members and military spouses. I mean, that is a directive from the governor's office. So sort of what's pushing this, because as of right now, while we have the rule in place and we have the requirement in the statute, no one comes close to being substantially equivalent. And even with if the recommendation from the committee moves forward, there's still not going to be anyone who's close to that. It's moving in the right direction, but it doesn't really help in terms of the governor's directive or the intent of the statute. That's all I wanted to say.
And if I could add briefly, I apologize. I do want to say that most of the military applicants, the applications that we do see, they have no problem meeting the experience requirement. The education is the biggest hurdle for them based on the current requirements right now, for what that's worth.
This is Vanessa, and I'm going to add something. Bill, I had the same thought. I've had the same thought a few times in the last couple of weeks, and I think when we get down to our general reciprocity discussion, if we look at going back to general education and experience, that proposal, I think actually ends up tying back more closely than the substantial equivalent when it comes to overall reciprocity, because we have a statute that ties to requirements for out-of-state applicants and what they have to meet. And like Denise said, generally speaking, I think the experience component ends up working out okay. But I think you'll really, I understand the concern because I have the same concern. And so I think Tony's right. Substantially equivalent, do we want a separate definition for when it comes to military spouse? Possibly. If we're talking general reciprocity, I think when we get down to that conversation and we pull the statutes, I don't think you're necessarily doing the exact same thing as you are here. But we can have that conversation, and I think it's a good one to have because I totally see what you're talking about on that too. And that's all.
Okay. Please remember to take your hand down if you have already said what you needed to say. Soccer, do you have something?
Yes, my question was, I think I can wait until later since we're currently talking about the reciprocity for the military spouse. I can wait until we get to the other reciprocity, but I'll just throw in that I'm with Bill on the making it harder for people when it comes to just regular people coming in. I'm not harder, but just keeping it strict. We can't just throw it away or give it away. So, all right, I'll lower my hand.
Yeah, so I really like the staff recommendation on this. I think that the big differentiator here is when it comes to general reciprocity versus a military spouse, one is voluntary and one is not, right? And I think that's the part that we have to keep in mind. I don't disagree with Bill that if we can do it without conflicting with statute, it would be nice if they had to be under another broker, even if they were getting a broker's license, so that there is some mentoring and things like that, maybe even for just 1 year. I don't know how, that could really be complicated to fit into a rule or a statute. But other than that, I mean, I think, somebody who's been licensed in another state, I don't necessarily know that they need principles 1 and 2. I think the promulgated law of contracts, law of agency, I mean, I know some of you are instructors, soccer I know is for sure. And, when we look at national classes that we teach, like ABR and things like that, some of the stuff we have to go in is specific to Texas and change, like, dual agency versus intermediary and things like that. Mm-hmm. So I think that having that law of agency, having the 2 contracts classes, and then having how we do brokerage here makes really good sense from an education standpoint. And if we're already meeting the experience standpoint, then I think really the only question that remains is, do they need to be sponsored by a broker while they're here, or can they operate independently?
How we doing?
Hello.
I have a clarifying question maybe for Denise or Tony. When we have someone come in and they're in this maximum 3-year period, and let's just presume that the state that they're coming from, that license is also 3 years. In this 3 years, is there any CE requirement? There's clearly not a renewal of license function. But are there requirements that they take CE within this maximum 3-year time frame where they have a license?
I would say that's it's a good question, and I don't think there is, because there's not a renewal of the license. So CE is required to renew your license. This is just a limited time period. They have to meet all the other requirements of the statute. So I think we need to look at that a little bit more to see if that would be a requirement. But since the license isn't renewed, I just on my gut I would say no. But we can look into that a little bit more. That's a good question. I don't know if Vanessa wants to weigh in on that or not, but again, as I said, I think the answer is no to that.
Thank you.
Hey guys, remember to turn off your microphone if you're not speaking. There's some rattling and stuff going on. Brian?
Yeah, thank you. I think with regard to the military spouse who wants to operate as a sales agent, I think that the state ought to recognize that license as a sales agent with the addition of those additional courses. I don't understand the 3-year time period when Texas is on a 2-year time period. it seems to make sense to me that within 2 years, that military spouse ought to meet the requirements of a Texas real estate licensee beyond to operate beyond the 2 years. It's a different conversation when we get to brokerage because it begins to talk about the experience points. I don't think we should have if we're recognizing a military spouse who is working as a broker in another state. First of all, I know that a lot of states only have real estate brokers. They don't have real sales agents. And so I think in order to come into Texas and start a business and sponsor agents as a broker, I don't think we should lower the bar with required experience points. I think we could lower the bar and recognize their broker license for a period of time, but then to operate a business beyond that period of time, and I'm thinking 2 years is appropriate. Then they need to be on a level playing field with Texas licensed brokers.
Thanks, Brian. Yasmin?
Yes, hi. I have a couple of questions mainly for, I think, Tony and Vanessa. 2 questions. What happens if somebody comes in as a military spouse and they end up staying in Texas? They retire, whatever the case might be. What, after the 3-year period, what happens to them? Like, what do they have to do to get permanently licensed? That's one question. I guess I'll ask the second one. Second question is there a distinction when they apply, if they're applying for a sales agent license versus a broker license? And should we have separate requirements?
Well, the distinction is they have to meet all the requirements. So to answer that one first, they would need to be sponsored. If they came under this this particular provision, they'd have to be sponsored by a broker if they were coming in as a sales agent and meet all the requirements of sales agent outside of SAE, obviously. But with regard to your first question, there's an echo, so I don't know if that's me or not. But with regard to your first question, they would have to go through whatever process is set up to get licensed outside of this particular provision. So the reason why, and if I could just answer the 3-year question because it pertains to this, the statute sets up specific guidelines we have to follow. And so right now, the way the statute's written is you don't have to have a license if you meet substantially equivalent requirements to come in. This is for any occupational license. You don't have to have a license if you're licensed in another state and meets those substantially equivalent requirements. You can just come in and start operating once you get the okay from the state. You still have to contact the agency, get them to certify that you meet the other requirements. Either you have a residency, you have a military transfer order, all of that stuff. But outside of that, you can start working. The reason the statute does authorize an agency to issue a license, and the reason why it'd be important here is because all of you know how difficult it'd be if you didn't have a license to work as a real estate agent or broker in Texas. You're not going to be able to interact with title agents. You're not going to be able to. I mean, it just would be a mess. So we've set up by rule the ability to issue a license to these people who come in under that particular provision. Did I answer your question? I kind of rambled there. I want to make sure I answered your question.
Kind of. So they would after, if they decide to stay, they would have to apply like anybody else in Texas, like for the sales agent, whatever.
They would. There are specific things allowable for not just military spouses, but vets and active service members. So substantially equivalent applies to that, but it gives the agency the authority to waive certain requirements. They're not waived automatically, which is what the sort of limited reciprocity license for military spouse does. That's more of that's a broader sort of authority to operate in the state. Yeah, that's and again, as I said before, it gets complicated, but you can always define things for particular purposes by rule. Right now, there's no definition of substantially equivalent. You could apply it to this particular provision have this particular issue apply just to this, or have it apply to all military related licenses, however you wanted to do that, and it wouldn't have to necessarily go towards, as Vanessa said, when we talk about reciprocity in a larger scale, it wouldn't have to go towards that.
Okay, and then I guess this is more for the group. So if somebody comes in, are we going to define like different rules if they're just applying for military as a salesperson versus if they're a broker in another state and trying to come in as a military spouse as a broker?
I think staff would have to answer that because there are states that only have brokers. They don't have agents. So that's a very valid question.
But usually in those other states, there are levels of broker license. So like New Mexico, for instance, everybody's a broker. But if you're going to sponsor agents, you're called a qualifying broker. And so there are two different levels of license there.
So I guess maybe if we could go back to our slide of the conclusions and we could see what our thoughts were and see how they can be correlated into our suggestions, I guess.
Hey, Tony, can I ask a question here that seems to be, what is our role when it comes to this to make it actually something useful? Because you said something earlier along the lines of whatever we do here may not matter anyways if we don't define substantially whatever comparable equivalent. Thank you. So I don't want to just like do something for the sake of doing it and it not actually be effective.
Well, the goal here is to and I think you're the one that actually mentioned this, that this one is voluntary and one is not. So it's the state is recognized, the legislature is recognized, and the governor, by signing the bill, is recognized that there is a need for people who come into the state because of an involuntary reason, their spouse or whoever has been stationed in the state of Texas serving the armed forces. There's a need to help those people be able to work and bring an income for their family while they're stationed in Texas. So that's what this would accomplish, is addressing that particular need, because as I said, right now we do not have any, there's no other state that's close to us. So when people come in, really the only thing we do for any military related applicant is we expedite the process of their application. And what we usually have to do is tell them, no, they don't meet the substantially equivalent requirements. You have to come in and apply, under this certain thing. I believe Denise has mentioned before that some of them meet the requirements to be a sales agent if they're brokers in other states. So we do that. We let them come in as a sales agent and they can, earn their experience that way. But it really is, we as an agency we don't do anything to benefit these these applicants in a way that the state has sort of dictated we should. Does that answer your question, Chance?
Yes.
Thanks, Tony. Bill, did you have another question?
Really, it was just a question for Tony. Is how do the occupational code, this applies to any licenses that are coming into the state? Is that correct?
Any occupational licenses.
Right. So how do other professional licenses get work here? I mean, can a guy come in who's a military and become an attorney, become an insurance agent, become a securities person, become a whatever it is? I don't know. I mean, how do other professional licenses, how are they handled with regard to this?
Well, I'll be honest with you, I don't know. I do know that other agencies set up specific rules to address the military spouse issue, and they do define certain requirements specifically to address that. A lot of occupational licenses are, for trades like plumbers and electricians.
Right, that's a different situation completely.
It is, in the sense that they don't, and in terms of how Texas compares to other states when it comes to that, it's probably fairly equivalent, so it's not that much of an issue. I don't know in terms of attorneys how that happens.
I don't think there is a transfer.
Right. I think you're probably right about that. But I can look at some of the other ones. That doesn't necessarily help with this particular decision making of this body right now in terms of moving forward. But you know, I could look that up and see how that works for some other people that may be more in line with what you guys do. But again, I want to stress that we're not talking about you know, this isn't like opening up the gate and letting people run crazy in the state of Texas. It's a fairly limited population for a specific time period for a specific reason. And again, it's to deal with the directive from the governor's office as well as the legislature saying we need to look out for these people. And someone mentioned something earlier, and I think it's a distinction in terms of sticking around. I mean, this isn't you know, this isn't like license portability where you can just come in and start working. I mean, it is to a certain extent the way the statute's written, but it gives us the authority to put some limits on that. But it's not like someone from New Mexico just is allowed to come in and immediately start working. I mean, they have to meet whatever we set up. So, and it's for a limited time period. So it's not just back and forth. And they have to prove residency. They have to be here. There's a residency requirement for this particular statute. So, you know, there is some skin in the game, if you will.
Thanks. You have something?
I just wanted to say that I do like the recommendation that the staff made. I agree with it. I do think that there should be, like, if there's a broker, that they can't just practice without being under another broker. But that's just my opinion.
Chance?
For the purpose of moving this along, I would move that this group adopt the staff recommendations on license portability for military spouses, giving deference to the chair and staff to make adjustments as needed to fit statute.
Do all of you agree, or would you like to continue to discuss?
I think you need a second and then you can discuss.
I second.
A second.
Okay, I saw from Holly, is that right? Did you second? So now the chair can open that up for discussion before you vote.
Okay. Can you go back to the staff recommendation really quick on the screen?
Yeah, Denise, can you throw that up there?
Sure, of course.
I know.
There we go. Can everybody see that?
Okay.
Yes.
So just to remind y'all that they require, I guess I also need clarification. What if our recommendations for licensing don't get accepted? So we're still back at our 900, or they do get accepted and we're at our 360. So is 50% to this group when we're at 360 okay with that? Are y'all okay? So if we get down to our 360 hours.
I would be okay with that as long as they're required to take those 4 classes.
Okay, no. Sounds good. And then I know that we've also brought up, in addition to actual licensing education experience, we also brought up within our survey that if the out-of-state applicant doesn't have the education and experience, then they would become a agent prior to becoming a broker. And I heard that before in this conversation today too, and I think we were in agreement with that. Is that something that could be added? Or does it need to be added?
Wouldn't that be an either or automatically by virtue of either you have it or you don't?
I guess but does it, I have no idea, I'm just asking this question. Does it need defined if you don't have enough for a broker, you can come in as an agent?
I would assume, and Denise could speak to this, but I would assume that if they don't meet the 50% threshold, whatever the current process is would still apply to any applicant that comes in.
Yeah, and just for clarification, are you saying that if they didn't meet the, our definition, whatever that ends up being, of substantially equivalent for the broker license, then we could, it's kind of what we do now for the out-of-state license holders who hold a broker license, that turns out they more closely align with the sales agent requirements in Texas. So I don't know, I mean, Vanessa could chime in. I don't know that we would need to spell that out, but it would just be the other option for someone who doesn't meet that substantially equivalent definition. The way that process works now.
Yeah, I think that's right. So what Denise is saying is currently just sort of in the real regular out-of-state folks, if they're not coming close to getting the broker, they can come in as a sales agent, right? And so here you would do a similar thing. So if they don't meet that substantial equivalent for broker, we would look and see, do they meet it for sales agent? So that is another path. I don't think you have to spell that out though, because if they can meet the broker requirements, or if they even come, if they've been doing something in terms of real estate, they're likely to get pretty close on sales agent the way that it's currently listed, right, Denise? Or it's not that much more to get there.
Right. And they would still have to take those 3 specific courses.
Right, which is what, 90 hours?
Mm-hmm.
Yeah.
Cheers. Oh, your hand's up. Okay. Yasmin?
Okay, so from what Denise was saying, so let's say that they do come in and they meet the broker requirements, so they become a broker. I would recommend that we still have them have to practice under a broker, kind of like, I know this is going to be the discussion for the other side of it, but I just want to get everybody's thoughts. Like, it's the same thing. Do we want a military spouse to come in and be a broker without having the experience here in Texas?
On our survey, we actually brought that up, and everybody wanted them to at least be sponsored or mentored for the first 6 to 12 months. So I think we need clarification on that.
I would chime in. I raised my hand, I'll lower it. When you look at the language of the statute and the language of our rule, which mirrors the statute, it's a recognition of that out-of-state license. So I don't know that we can add that. I mean, I don't think we can add that requirement in. Right, Tony? I mean, you and I have talked about this a little bit in terms of.
I think you're right about that particular provision of the statute. I really don't want to complicate things, but I think you could, to the extent that you want to address at a later date, all military licenses, because I know this is focused on this particular provision for military spouses. I think there might be some wiggle room in there to have that. So for vets or active military members or military spouses who aren't coming in under this provision, I think you could do it at that point. But I think Vanessa's right in terms of the confines of 550041, which is specific to this out-of-state military spouse. I don't think you can add any other requirements to it because you have to recognize the license.
So that could be something that you bring up post, when we meet. We're going to take a little bit of a break, let session start, and then you guys will have sort of a series of new topics you discuss. And I think, Tony, that's a really good point is, do you want to consider that elsewhere? I don't think you can consider it here. But again, I know we keep saying it, this is a real limited group. But the statute is pretty specific. It's a recognition of that out-of-state license. So adding in a requirement like that, I don't think works here.
Question?
When you say real limited group, and y'all keep saying that, are we talking like 5 people a year or 100 people a year?
Right now, it's no people a year because they don't meet it. So we don't really know, to be honest with you, outside of the fact that we're thinking about the number of military spouses that come into the state of Texas who are transferred because of a, an order, and who are licensed as real estate agents or brokers in another state. So that's why we keep saying that, because we, anecdotally don't believe that's that big of a population.
Yeah, and I can add just a little more specifics to the people that we've told that the requirements are not substantially equivalent. It's fewer than 10 people this year.
No question.
If the recognition of the license, I'm still real concerned, and I think there's a feeling that there has to be supervision, that they shouldn't come in as a broker, even if they have what's called a broker's license in another state. They shouldn't be able to run agents, operate offices, do stuff on a temporary basis like this. It's not a question of not being able to practice real estate, but they should be able to practice real estate within certain confines. And it would, if you're saying we can't say that we can recognize the license, and then and that recognition would be that they would come in as a sales agent in Texas under the supervision of a sponsoring broker, if they met the substantially equivalent requirements, whatever we decide. It would seem to me that would be a rule. If every group can create their own rules, that would be something we might want to consider. Again, I'm not trying to prevent people from doing business, but in a responsible way. And again, that's just a suggestion.
Jasmine? Jasmine, do you have your hand up? Okay, so a couple other things that we had all agreed upon, and I don't know if they can be part of this or not. Well, actually, one of them we already did, that receiving the Texas, be required to take the Texas classes. And then we talked about all applicants having to take the state exam prior to licensure. Does that not apply here? Staff?
Yeah, I didn't know if Vanessa was going to weigh in or not. I don't believe you could require them to take the state license or the state exam for this particular license, or an applicant coming in under this particular statutory provision.
Yes, I would agree. It's going to go back to that recognition of an existing license issue. So I don't think for this group.
And another thing that has been brought up a couple times was, and it really makes sense actually, our licenses are renewed on a biannual basis. Why is this 3 years?
Okay, because it's the statute says that so if you take out of the consideration that we're issuing a license, which we're doing under the authority of the statute, but the applicant, all things being equal, could operate without a license in the state. That's essentially what it allows them to do. They just need to get certified by the agency that they can do that. The statute says it's for the time period in which they're stationed, or 3 years, whichever is less. So we have to take into account that the license says they can do it for 3 years. Again, it's tied to how they're licensed in another state. I don't believe there's any 3-year licenses in other states. I think they're either 1 or 2 years.
There are 3 and 4s.
I'm sorry?
There are some 3 and 4s.
Okay. So, but it's tied to that license. So, yeah, by statute, we have to recognize it for that 3-year period.
And based on that, similar to the way we handle temporary out-of-state appraiser applications, we can go in, staff can enter the expiration date of that approval based on when that license in the other state expires, or when those orders, to come to Texas expire. So we'll be able to comply pretty easily with that part of the statute of, whichever term is less. We'll be able to customize that because it's not a license that's going to be renewed.
What happens if the license in the other state expires in 2 months from the time they come here?
We would plug in that date and let that person know, you know, they're going to have to, and I think Tony mentioned this earlier, that if they want to continue to be able to operate, they'll need to show us evidence that that other license has been renewed.
Yeah, the onus is on them to make sure that we're current. I mean, we'll plug in a date based on what their license expiration is, and if it's 2 months and they don't come back to us and reinstate that or go through that process, they don't have the authority to operate, and because they have to, at the very least, get certification from the agency. So even without the licensing component of it, they'd have to come back to us and ask for certification, and if they don't do that, then they're operating without a license in the state.
Right, which brings up the other point, Tony. They're still subject to all of our rules and regulations. So it's not as though they're just out there able to do whatever they want to do. And it's another reason that it's good for us to actually issue that license number, because it's our tracking system too, right? So it doesn't just. It's not just, it is recognition, but it's also, they're going to still be subject to the licensing agency. And if they're doing things they're not supposed to be doing, they can be turned in via the complaint system, things like that.
Okay, so we still do have a motion on the floor. Is everybody good with the motion as it stands?
So you can call for a vote, Leslie. And you're welcome to do that. If you want to do a roll call, Amber can do a roll call, since this is a big one.
Okay. Amber, do you want to do the roll call?
Sure, I can do that. Bob Baker?
Yes, but could you reread the motion, please?
The motion is to accept the staff recommendation requiring 50% of the number of hours of education and experience requirements, plus completion of the following 30-hour qualifying courses: promulgated contract forms, law of contracts, law of agency, real estate brokerage.
Thank you. I vote yes.
And also, just to clarify, this is Amber. I think, Chance, you also had said to give authority to the chair to work with staff to make any changes.
As long as, to make any changes necessary to comply with statute.
Okay. So Bob, that was yay?
Yes.
Okay, Chance?
Yes.
Soccer?
Yes.
Holly?
Yes.
Leslie?
Yes.
Yasmin?
Yes.
Bill?
Yes.
Brian?
Yes.
Pam?
Yes.
Okay, all yeses.
So I guess that we don't need to go over anything other than substantially equivalent. Is that true? Or do we need to go through the different sections of credit for military service? I'm asking staff. Motion carries on the last as well. Thanks.
Yeah. I think that that's what we were really looking at, was that recommendation on substantial equivalent, because that's where we needed a definition that that actually worked, right? And you guys have proposed one, so I think you're good on that. Tony, you agree? Is there anything else you think we need to see?
Well, I'm sorry, I just want clarification that this is specific to that provision of the statute 0041, or is that for all military?
I understood it just to be under military spouse.
Okay, yeah.
That was my intention with the motion.
Yeah.
Okay, good.
Yeah.
That's fine. I just want to make sure. So yeah, you're right, Vanessa.
Yeah. That there is still an outstanding question on the other military categories, but I think that is for another day.
Yeah, and it addresses military spouses who come in through the normal process and not through this process that's set up by this particular statute. So that's, again, for another day, but it encompasses vets, active military, and military spouses who come in through that direction. And not
Right. So what Tony's saying is there's actually two provisions. There's one that's the one that you just were looking at specific to military spouse. There's another one that applies to different categories of military, and it includes military spouse. It's a little bit different. I think we haven't given you sort of the information on that one, and I think in some ways it might be better to have that separation of here's what we did on this, and then look at the other one more broadly, because I think there is a little bit more discretion in that one. So that can be picked up at post-November meeting.
So the next item is item number 8, discussion and possible recommendation regarding real estate broker reciprocity. Does the staff want to speak first on this? Does anybody, let's stop a minute. Does anybody need a little break for like 5 minutes?
Yes.
Yes.
Okay.
I couldn't quite hear that. Did you say 10:50?
Yeah, why don't we just come back at 10:50? It's 10:41 now.
Okay. Everyone, can everyone mute?
Okay, so we're going on to reciprocity and portability. So I think we talked in the last meeting that reciprocity isn't as easy as it sounds. The state would have to go out and make agreements with other states to have a deal in place, so to speak, for their licenses to come to Texas, which I think we all feel would be a burden on staff and maybe the easiest route to go. So it may be best to talk about portability more than reciprocity and how we can define that and what it would look like to us to let people come and start practicing real estate in our state. Does staff want to read this out?
Yes, I think that I'm going to go ahead and pull up two statutes that I think, while they don't specifically say portability, like she just said, reciprocity is not really where you guys are seeming to head. It will help show what I was talking about before, where I said I think your education and experience requirements start to get us what your recommendations start to get us somewhere where it's a little bit more feasible for someone to come in and not have, 900 and something hours to catch up to. Let me show this, and then I'll go through it just a little bit, and then after that, Denise is going to walk you through the process we currently have, where we do give credit for certain courses taken by folks who are trying to come in from out of state. This is a big topic, and so if you don't reach like an official recommendation today, it's okay. I think your education experience recommendation ends up tackling quite a bit of it. So this is one you can really open up for discussion and think about. Let me share. Okay. So if you look here, this might actually be helpful for you guys in general, because I don't know that we've ever actually shown this. 1101-356 is what we were talking about when we say we need to make recommendations to change, and it impacts statute, right? Because this is the statute. What this statute says is here are your education requirements, right? And this is what you guys have made some recommendations on. And then here, if you look, we have we actually have rulemaking authority on experience requirements. So it's kind of a hybrid. It's both statutory and in rule. And And then if you look at 357, this is alternate experience requirements for certain applicants. And so this is where we're seeing folks who are coming from out of state, and we have different experience requirements so long as they meet those educational requirements in the statute above. And I think Denise will tell you, we don't often see, I think she will tell you this, she can interrupt me and tell me I'm wrong. With the experience component, the 4 years and the active real estate license is not usually the hurdle. The hurdle is usually those educational requirements. So once you have a recommendation up here to lower those education requirements, you are in a better spot of getting folks who can more easily transfer over to this state. And so it, you know, I think this opens up a big discussion. I'm going to let Denise walk through the process, and then I think Leslie, we're going to turn it over to Leslie, and she's going to go through your survey responses and the ideas that you guys had, and just like really allow for a robust conversation on this topic, because this is a big topic.
Yeah, thanks, Vanessa. And I'm going to share my screen and show you guys the rule, because this will help explain our current process. So right now, when an applicant comes in, you know, and they hold a broker license in another state, they will submit, you know, proof of all the courses that they completed to obtain that license, and will generally ask for additional information like course content outlines and, you know, additional information about the courses, and we will compare it to these, you know, content requirements that are laid out by Rule 535-64. So, you know, we don't award partial credit, but we go through and check, you know, each of those courses, because of course they're all called, you know, by a different name in the other states. And so we give credit where we can when the course content of the courses that they took for the license in the other state match up to the content of, you know, the courses in Texas. So generally speaking, like Vanessa said already, the experience requirements are typically not a hurdle for those applicants to meet here in Texas. It's the education. So, you know, we award what we can based on that review, and it's a side-by-side comparison of the course content in the other state to the content here in Texas. It's required. We'll look at transcripts for college courses, just like we do for, you know, a normal applicant who is in Texas wanting to upgrade to a broker license. So that tends to be the biggest hurdle for them, is the 900 hours currently required. So then at that point, we can provide an evaluation, tell them how many hours are still lacking, and once they do meet that, at that point is when we authorize them to sit for the exam. You know, they go get fingerprinted at that point, and we go from there as far as the normal license process.
Right, and that is something that Denise pointed out. There's a whole other process after that. So unlike what we just talked about with military spouse, where it's that recognition of the license, you do have that exam portion. So it's a little bit different. There's some more requirements in there.
Yeah, sorry, if I can add one more thing. This, like you said, this is the normal process. So that means that once they pass the exam, they get fingerprinted. If it's a sales agent applicant that's coming in from out of state, you know, they obtain a sponsor, they get the license. Now they're subject to all of the renewal requirements. So if it's a first-time sales agent renewing, they're going to have to take the SAE education, then additional 90 hours, and a broker license. If they sponsor, they're going to have to take broker responsibility as part of their CE. All of those normal renewing requirements will apply once they go through all of those other steps to get that license.
Can you also go over our kind of way of going about the national exam and waiving it?
Yes, sorry, I skipped that part. If the applicant is coming from a state that participates in the ARELO exam accreditation program, we will issue them a waiver for the national portion of the exam. If they are not coming from a state that participates in the ARELA National Exam Accreditation Program, then they will have to take both the national and state portion of the exam.
Does anybody have any questions for staff before we start diving into this? Okay.
I think I saw Brian. Is that right?
Oh,
Yeah,
Brian,
yeah, thanks. Just a question. I know we're going to enter into this conversation about license portability and license reciprocity. Reciprocity. And is that one topic or is it two topics?
I think we're going to break it down quickly because I think most of us know reciprocity is a little bit harder of a process to go to. So we can touch on that since we did talk about it, and then kind of jump into portability and what that may look like. How's that? Okay, good deal. So actually what I think we could do is put up the conclusions we found on the reciprocity portability slides. Okay, perfect. So like I said to you in the last segment of when we were talking about military, we do have all these slides. I took everything and I put all of our responses together and kind of lined them out. But just for the sake of time right now, since we kind of are going to jump to portability, we don't need to go through every page. If y'all want copies of this, I'm happy to send it to you. And it would show everything put together from what everybody said. So from our conclusions for license reciprocity, we thought that out-of-state sales agents and broker applicants must meet Texas education requirements prior to being considered for a license. Out-of-state real estate courses can be considered for part of the Texas requirements. The applicant must take Texas-based classes, like we just discussed earlier, promulgated contracts and other Texas classes. The applicant must use the same broker experience point system that we currently use. Out-of-state experience can be credited toward requirement if it's verifiable. The out-of-state applicant must take the state exam, but not the national exam. And then the out-of-state broker applicant should be required to work under a Texas broker or supervisor for 1 year prior to being fully licensed as a Texas broker. So that's kind of what we came up with. Some items to consider was don't use the word reciprocity, offer an education waiver. Classes that have been taken can be counted towards the current requirements, but Texas classes still must be taken. The applicant must take the state test, but the national test can be waived if the applicant is from the state that participates in ARELA. If entering Texas as a broker, they must initially work under a Texas broker. We must consider that some states do not offer sales agents license. All licenses are brokers in those states. And I think Chance may have given us a little bit more information on that a little bit ago. Currently, there are not states that have equivalent requirements. So regardless, negotiating and maintaining agreements with other state associations could create a greater workload for the TREC staff and have more complications than benefits. Chance. Chance, I see your hand. Chance, are you there?
I think he's on mute.
You may be having the same issue I had. While we're waiting on Chance, oh, Chance took his hand down. Okay. Oh, I think he's getting back in. It said he was leaving, so let's see if he comes back in. While we're waiting on Chance, I think Vanessa said these slides were posted last night. So we want them. Here he is. Chance, did you have something to say to us?
Hold on, we got to let him in.
Hey, Chance, welcome back. Where is he?
All right, can you hear me now?
Now we can. Welcome.
All
There you go.
So my questions were, number one, this education waiver seems to be the easiest way to accomplish what we're trying to accomplish without having to go around statute, without having to go around rule, and allow staff the opportunity to decide what does and doesn't get transferred, as long as we have some set regulations, like you have to take promulgated contracts and law of agency, or whatever those, if it's the same courses that we talked about before. But the second one is specific to the experience points. Well, this, when it says out-of-state experience can be credited toward requirement if verifiable. If verifiable is iffy to me on not necessary sales and listings and all of those things, because that's an MLS sheet. But what about management? And I'll go back to the example that I've used before. The guy who used to run Coldwell Banker United for the state of Texas and oversaw $5 billion in real estate sales couldn't get a broker's license here. So I just think that's something that, if we're going to look at those the experience point system, is that just universal, or what is verifiable, what isn't, I guess?
I think in our recommendation, in our current experience points documentation, it does talk about management, and they do get points for management. Asking verifiable.
In the current system, though, there's a cap on those points.
Correct. Our recommendation, I think, had a cap as well. But that has to, I think the experience sheet that we have also has to be verified by a broker or somebody that this person's working for, correct?
Yeah, it would be the same process, if I may. It's the same process as a sales agent licensed in Texas who wants to upgrade to a broker license. They have to provide the same documentation. It's the experience report, a transaction listing, signatures where required from the sponsoring broker, and there are alternative documents to verify that information. If they can't get the signature, or if they were a broker in the other state, how do they get somebody to verify that experience? So it's a similar process.
Okay, and am I right in my first supposition that if we ditch the word reciprocity, just call it an education/experience waiver, that really makes your life a whole lot easier at staff level?
That actually describes the process now in reviewing the out-of-state coursework against the content requirements by rule. So that it's, I think it's just a terminology thing, but it's the same thing where we try to apply credit where we can for the courses that they've taken that meet our course content requirements. We don't do partial credit. We don't Frankenstein them together. Half of this course meets half of this other one. We don't do any of that. But it's the same process, so it wouldn't be any more difficult than what we're doing now.
Vanessa?
So then, Denise, is it true that with that lowering, let's say they move forward with let's say the commission moves forward with the lowering of the education requirements, does that, with this sort of, we're going to call it the waiver process, does that make it significantly easier, a little bit easier? I mean, what do you think about that? Do you think we're already somewhat addressing it by doing that, by lowering those requirements?
Lowering it does make it easier, because that's usually the hardest conversation that we're having with applicants, is that you're going to have to take these specific courses, qualifying courses, and you still need 600 hours, in all of your CE or any other real estate related courses that you may have taken. So yeah, that is going to help out tremendously, not just from like our reviewing standpoint, but also for that applicant coming in, because there is no getting around the Texas coursework right now. And so adding the additional 630 of related, that's usually what ends up being the biggest hurdle for those applicants.
Okay, so I'll just say, Bill, I think this goes back to your point earlier today this is where that conversation starts to happen, where it's distinct from the military spouse issue. Is it really is going to tie back to the proposed education requirements and lowering. And I will stop talking now. But I just wanted to tie it back to Bill's initial point from earlier today.
Brian?
Yeah, to Chance's point there, in neither our current education, or I'm sorry, experience requirements or our proposed experience requirements, in neither case can a 100% manager, regardless of how much he manages, qualify for the experience points in a 5-year period. We're not giving enough points for management experience for a strict manager, who does no transactions. There's no way he can meet the experience requirements.
Anybody else?
Okay, it's Bob. If I can speak to a little bit of what Brian and Chance are both saying. And I remember when I went through the previous meetings and watched the videos, and this was brought up, and there seemed to be some sense that in order to be a broker, that you had to at some point in time have done production. I don't find that to be real world. I don't find that to be true. Some of my top producing agents will never be a good broker, will never be a good manager, and vice versa. I think that it would be a huge disservice if our experience didn't allow someone like Chance mentioned, who has significant experience, to be a broker. That maybe your last 5 years, 10 years, 20 years, and basically my last 20 years has primarily been totally management, brokerage, no production. If I'm required to have production, I could not be a broker, and I think that would not be the right thing. We've got to be able to give someone with pure management experience the ability to continue to move up to be a broker, to do that. I think requiring production would be a real disservice to the function of what a broker / manager is. So whatever, if that's something we've got to undo or change or whatever, I'm absolutely on board with the education, dropping the education, increasing experience, but we've got to somehow give pure managers the ability to qualify without any production at all.
Amen.
Just to weigh back in, 7,200 hours or 7,200 experience points divided by 60 months, which is 5 years, is 120 points per month. 7,200 experience points divided by 48 months, 4 years, is 150 points per month. And currently we credit 20 hours per month, and in our proposal, we're at 40 hours for 40 points per month.
But I would say if there's the possibility of waiving some of those experience points from other states, if it's verifiable, that might cover some of that, Brian.
Or the option might be that we amend our recommendation for that category of experience, awarding more points for management than we're either currently requiring or currently proposing.
I'd be cool with that too.
Bob, do you have something more? Bob, did you have something?
You're muted.
You're muted. There you go.
Okay, so I think if we use the numbers that Brian's working up, Chance talking about, so for management, we gave 120 points or 150 points credit for management over the time frame we're talking 4 or 5 years, then that resolves giving the credit for management for qualifying for experience. I think if we up those amounts from 40 to those other numbers, it would make more sense to me.
Soccer? Soccer, is your hand up? Soccer?
She may be having the same issue. Oh, are you there? She'll have to come back. I think she got super muted too.
Thanks a lot, Vanessa.
I wish I could super mute, not you guys, but there are people I wish I could super mute, generally speaking. Never this group, though.
Oh, thank you. Anybody else have any thoughts on this while we're waiting for Soccer to come back?
So now we're talking.
I like what Brian and Bob are suggesting. I think that makes a lot of sense.
Staff, what point are we at that we can maybe go back and amend if that's what the committee wants to do?
Can I?
Yasmin, yeah, sorry, I didn't see you. Go ahead. You're muted. You're muted.
Okay, can you guys hear me? Okay. I know we had like a long discussion about this before, and I do still feel that I'm okay with increasing the points as they're discussing for management, but we did discuss this, and I do still feel that there should be some transactions be done in order to become a broker. Like everything changes, the lending process changes, and that one-on-one with the clients, it's different. Like if you're gonna be a broker, we talked about this, you have to be completely well-rounded. So I don't agree that we should change to have whatsoever no transaction experience. I'm not okay with that.
I agree with you too. I think people need to stay in touch with what's going on and not just be behind a desk managing those parts.
My argument to that would be that every BRWG office in the entire state of Texas has non-competing managers. And so you have tons and tons of managers already licensed brokers in the state of Texas that haven't sold a home in a decade or more.
So for them to become a broker, are they becoming a broker because they want to open their own shop and then get into it more? Or that's the question. If they're looking to open up their own brokerage, do they have that experience to do it?
I mean, I got a call last week from a guy who is managing a RE/MAX office in Dallas who cannot get a broker's license because of the cap on experience points. He can't compete with his agents because of his contract. And he was a sponsoring broker in New Mexico for 21 years that had a brokerage there with over 150 agents. And he can't get a broker's license in Texas.
Well, like I said, I'm okay with adding or changing the management experience points that they outweigh, but I don't think that there should be like zero experience on transactions.
But what about that guy who has been a sponsoring broker for 21 years in another state? He can't do a transaction here because his contract won't allow.
Is there any oversight on this that can be discussed on a case-by-case basis?
I'm going to ask a question here, because it seems like we have gone perhaps back to education experience generally, right? Because the conversation, I just want to make sure I understand it, and it's okay, we can go back to that agenda item. We're not so much focused right now on out-of-state applicants, right? Because we have, they have two methods, right? They can get in under the current way, or they have alternate experience requirements in statute. That's what I showed you before. And I think Denise said a lot of them are able to get in under those alternate experience requirements, which is the 4 years I keep saying 4 years and then forgetting the rest of it. It's they have to hold the real estate broker license in another state, and they have to have 4 years of active experience and during the last 60 months. But what I just want to make sure I understand, because I think this is the question that Leslie had asked me, is are we revisiting your are we revisiting your experience recommendation under, and I know it's not agenda item 1, I think it's maybe number 4, on that recommendation, and that's okay if we are. I just, to clarify what we're talking about, we've kind of moved from that out-of-state applicant to the big topic, right? Yeah, okay. So let's take it back to that item, and we can pause on, because I think they are so tied, we can pause on the, I'm going to generically say reciprocity portability item.
Okay, so going back to number 6, education and experience requirements.
Yeah, to the extent you want to open that discussion, Leslie, it just sounds like that discussion opened under the other agenda item. I just want to make sure we're all clear on that.
So I think we're still good, and I understand, but most of on the management experience and how that is tallied or counted. I think soccer is something that soccer, are you back?
Can you hear me?
Yes.
Okay, yeah, I wanted to weigh in on the poor person who, you know, with Coldwell Banker United, who's been a manager for, you know, 20 years and managed all of these people, and maybe they are leaving to become their own brokerage, or maybe they just want to, you know, have that option should it present itself later on. And with the current points, they are not able to reach that within 5 years. If somebody could remind me, because I'm not looking at it right now, what is our current proposal for a person like that? I mean, for experience points. All of their 7,200 experience points can come from management, correct? We did change that cap, right? That's our proposal.
I'll jump in if it's okay. Soccer, what I was just pointing out is under our current experience requirements, we award 20 points per month for management. And in our new proposal, we've increased that to 40 points per month. In a 60-month cycle, 5 years, that would allow somebody to earn 2,400 points towards the 7,200 total experience point requirement. We would have to increase those points per month to either 150 over a 48-month period, or 120 points per month over a 48-month period. So, I think the experience in management is as valuable and as pertinent as the experience gained doing a transaction. I do both. I manage and I do transactions. And I'm confronted with more complexing problems in managing the agents and their transactions than I probably encounter myself.
Yep.
I agree 100%. So I do think that maybe, you know, when we do that, we are able to give that person the option, because otherwise, after 20 years of being the regional manager or whatever of the Coldwell Banker United, and to start a real estate career in hopes of getting their broker's license, they're now going to have to be a salesperson for 4 years and then go for their broker's license. So maybe we'll might need to tweak that, or like Leslie said, on a case-by-case basis.
Well, then going back to my original point here, if we're doing an experience waiver and the state is determining what's verifiable and what's applicable to that, you know, that can cut a number of those points down. I don't disagree with what Brian is saying at all. I agree 100%. And if we need to move that number up from 40 to 150, I would be perfectly okay with that. But if in the example that I used, you've got somebody who was a qualifying broker who ran a brokerage with 150 plus agents for 20 years. I would think that the state would look at that and grant some experience points.
Jasmine?
I agree.
Can somebody make a motion to that effect?
Hold on, Jasmine has her hand up.
I would move that we change the experience points awarded for a manager to 150 points per month, which would allow a manager to accumulate the 7,200 experience points required over 48 months.
I second it. Soccer.
So you guys can discuss this and then take a vote.
Okay, is there any more discussion? Amber, do you want to do a roll call?
Sure, I can do that. Okay, Bob,
Yes.
Chance,
Yes.
Soccer,
Yes.
Holly,
Yes.
Leslie,
Yes.
Yasmin,
Yes.
Bill,
Yes.
Brian,
Yes.
and Pam.
Yes.
Hey, unanimous.
Motion carries. Do we have any public comments right now? I believe there's some people on here that may want to comment.
I think we have the written comments.
Oh, okay.
So once you guys finish with this, you have a choice to make of, and it sounds like you just voted, but if you guys are done with the discussion under item 6, you can either move back to your reciprocity discussion, you can put that on hold and see where all of this other stuff plays out since it is tied to it, and move on to your written public comments. That's up to you as the chair, but those are some of your options. Since it sounds like, from what I'm hearing on your reciprocity discussion, it really does weigh in so heavily on experience and education and seeing where that ends up landing with the commission and with session and all of that.
I mean, if we're talking about this portability and reciprocity, even with current or future education experience requirements, if we are talking about a waiver, it kind of would still be pertinent. Chance, your hands up.
So I hate to beat a dead horse. Denise, maybe you can help here. Using my example of the guy who was the sponsoring broker or qualifying broker is what they call it in New Mexico, for 21 years. And if he was going to come to Texas and he wanted to get a waiver of experience points, what does that process look like, and how many points would he get, et cetera, as far as trying not to use the word reciprocity, trying to say this waiver?
I guess to clarify, I mean, it would be whatever is set by statute and by rules. And Vanessa mentioned the alternate experience requirements by statute that say, 4 out of the last 5 years of the active experience, and we still point them to, the experience report form where they have to provide the transaction listing, just like an applicant upgrading from a Texas sales agent license. So there's no, unless you guys decide to put forth a recommendation that says there be alternate experience requirements for somebody coming from out of state, it's not a different process to prove up that experience.
Okay, so in theory, if this person had been actively managing people for 4 of the last 5 years, he could get all of his experience points waived.
Based on the proposed recommendation that you guys just amended, then
right.
Yeah, if that were to go through, then yes.
Okay,
and
thank you.
If they fill out the same form and the same signatures and certifications that someone who's upgrading would submit.
Thank you very much. Madam Chair, if that is the case, my recommendation would be we wait until session to go any further on this.
Do all of you want to pause the?
I'm sorry, Chance, can you repeat what your recommendation is?
My recommendation was just to table this reciprocity / waiver discussion until session and we get what we've proposed approved, and then be able to circle back and actually have it be applicable. Sorry.
I agree. I agree.
I think what we've done with that recommendation is we've leveled the playing field for reciprocity by out-of-state brokers or out-of-state applicants requiring the same experience that an in-state broker applicant would have. So I think I like that level playing field.
Yeah, but we don't have reciprocity or any definition of that.
No, but we do have that. You do have that statute that we currently use to get out-of-state applicants in,
Right.
which could, if your recommendation goes forward, would serve to help those out-of-state applicants meet those requirements. While it wouldn't be a true sort of portability in the way that we're thinking, it has that same impact, right? Of getting people in under requirements that, one, we think are acceptable for our folks in Texas, and also allowing them to come in. They do have that alternate experience option, which it sounds like is used, but I think your impact in terms of getting folks from the outside in is the same. It should all of that move forward, right?
Okay, because I know also people were talking about portability concerned about out-of-state licensees do commercial transactions or other transactions on a case-by-case basis, which I think we were pretty much saying that they should only get a referral fee. So is all of those discussions and points, is that what you want to bring up at a later date, or did you want to go through any of that and get a consensus on where we stand on anything? How did you want to proceed?
Who are you asking that question?
I'm asking if everybody's just ready to say, okay, done, this is it, or
no, I think we could still have those conversations. I'm just talking about the big picture reciprocity. If we want to have the individual transaction conversations, that's fine with me. I just, from the big picture reciprocity, if we're talking about education and experience waivers that are contingent upon this proposal being adopted, I think it would be smart to read on anything that's contingent upon this proposal.
Yeah.
okay. I mean, in general, even if this proposal is adopted, I think how have some of the education they could towards their license with the true waiver. It's for a class basis.
I'm sorry to interrupt. I'm actually having a hard time hearing Leslie. Is anybody else?
Yeah.
Yes.
All right. Sorry, Leslie.
I don't know what it is. It's not me.
It might be where your mic is on your computer. I can't tell if you having your arms up is kind of, because sometimes we've had it where people have had papers around and it blocks that microphone. So I don't know if you want to try a different position or something. That's my technical expertise right there.
Okay, I'm trying to know where my mic is. I think I see my mic. Anyways, so what I was saying is, no matter what goes on in this session, if somebody is coming from out of town or wanting to get a license, that waiver thing can still stand, saying, okay, you have these classes, but you're still going to have to take these classes. So I don't see how that's going to change anything. It's just the number of hours that we're looking to change. So waivers are like, I'll waive this class for this class. Is that your thought? Is that how you understand it? Phil?
So, and maybe I'm looking at it too narrowly, but to me, the reciprocity portability issue is all about getting a license and giving experience credits and trying to help qualify somebody to actually get a Texas license. The issue about sharing commissions with outside brokers from outside states, from working with outside agents from outside states to do transactions, I think is a different issue completely. And I don't think it necessarily has to do with the education requirements or the portability or the reciprocity questions at all. So I think that, and I think it's a real important discussion, especially in the commercial realm, because we're doing a lot of national work. A lot of Texas brokers and agents are doing stuff all over the country, and people from all the country are doing stuff here. And certainly there's, I think that is an issue that we do need to talk about separately. And I don't know that it needs to wait until, we determine what the educational requirements are.
Agreed.
So, yes, and the definition, so to speak, of license portability is it governs how out-of-state agents or brokers may or may not conduct business in another state. And there's 3 different kinds of states. There's a cooperative state, physical location state, and a third state. Right now, we are a physical location state, which means we allow out-of-state agents or brokers to conduct real estate business in our state remotely. For example, you can negotiate and submit offers on behalf of your clients as long as they stay in your current license location. You cannot accept a commission per se, and I may be wrong at this, and Tony or somebody step in, but you can collect a referral fee. Is that correct? Staff?
I actually don't know the answer to that. I don't know if anybody else does.
Okay. I don't.
Say the question again, please.
The question is, in our state, you can't actually work here as a licensed broker and get commission or co-broker or something. You can get a referral fee from a Texas agent, but not in the form of like a real commission. Is that correct?
Well, you can't physically work in this state if you're in another state, but you can pay a referral fee, and there are no parameters on how much that referral fee is. It could be 100%. So it can be anything. You can pay a referral fee to anyone who's licensed in another state or in another country, that as long as they meet those requirements. They just can't physically come here and negotiate.
And our enforcement director, Mike Malloy, has his hand raised. He just lowered it, I'm guessing, because he confirms the answer. But Mike, do you want to speak to that?
Yeah, Mr. Baker's correct. This is Mike Malloy. Yeah, you can be 100%. They just can't do any brokerage activity for the transaction in Texas. They basically, a foreign broker, I think that's how it's defined in the statute. They basically have a contractual relationship or agreement to give a referral after the brokerage activity is completed, the transaction's wrapped up. So,
and I think that's what our group kind of agreed with. We all agreed that an out-of-state agent should be able to collect a referral fee, but not a commission through their out-of-state broker. We agreed that all license activities relating to the sale of a property in Texas should be performed by a Texas licensee and in the name of the Texas broker. We agreed that, actually we were split on if a co-brokerage agreement should be for commercial properties only. We we said there should be a promulgated co-brokerage agreement form. And that's only if they were going to be accepting a commission, I believe. And then Texas should not offer a temporary license for a specific transaction. An agent or broker must be fully licensed in Texas to conduct business in the state. So with all things considered, it's pretty much, we don't want to change the current regulation where portability in this sense of the word is used.
So it sounds to me, if I'm not, oversimplifying here, really the discussion we need to have is on this, are we going to refer to broker lawyer a request for a co-brokerage agreement? But everything else, it seems, remains the same.
I don't even know if we need that, if we're going to just continue to have everything like we have it now. I mean, if you're just paying a referral fee, and I don't see why you would need a co-brokerage agreement.
Sure. Bill, you and Bob probably deal with this more than any of the rest of us. So if y'all want to weigh in.
Well, I really would like to. The real issue is that out-of-state brokers are doing stuff here. We're selling properties with out-of-state brokers, and I'm asking the question of the enforcement folks. I mean, it's my understanding that a principal can pay a broker wherever they're from. They can pay whoever they want to, whether they're a broker, they're an agent, whether they're the janitor. They can pay whoever they want to money, and whatever it's called. And I think that's sort of the elephant in the room. That's what's really happening all the time. Is that it's not that that the agents are doing stuff, and they are practicing real estate. They're making transactions, they're doing stuff, they're facilitating the transactions, and it's all about who's paying them and how it's getting done, especially on a national scale when we are dealing with people coming from out of state. So I think, and I'm struggling with it, is that in fact what the rule is that a principal can pay anybody that they want to?
But you can't, the principal, but you mentioned
Yeah, I'm talking about the principal. I'm not talking about broker splitting.
But you mentioned paying a janitor. We, as licensed agents, can't pay. And I'm like,
right. But so what happens is in the real world is the agents aren't splitting commissions. The principals are paying the commissions. And so what's really going on is that there's two things happening here. One is who's getting paid and how they're getting paid. I think that's already been taken care of by principals being able to pay brokers wherever they're from. But the second part is what's the legal liability for somebody, and what's the right for somebody to be handling the transaction. If I'm dealing with a guy from out of state who's selling a piece of property in Texas, and I have to do all the work, even though they're the agent who's got the information, they're doing stuff. It seems like, there's a disconnect here. They're getting paid anyway, and I'm having trouble figuring out why we can't, why an outside agent can't be doing a transaction in the state. And this is transactional. It's not owning a brokerage commission, owning a brokerage house, running agents. It really is a transaction by transaction situation. I'm sorry to be clumsy in how I'm describing it, but it's not operating an agency or operating as an agent or a broker. It's facilitating a transaction in the state and getting a commission.
So I'm unclear, because technically it's not the principal paying. You have a listing agreement, and that the commission goes through the listing agent.
No, that's not how it works. I mean, what's happening? There is a listing agreement, but the listing agreement says that when it all comes down to the end of the game, the contract is going to say that the principal is going to pay the brokers these amounts of commissions. And that's how you get around it. And also, now the situation where an outside company, an outside a broker is doing a deal in Texas and wants to get paid by somebody in Texas, and he doesn't have any connection with Texas, some of the outside brokers have come and said, will you allow me to be your, will you allow me to refer to me commissions, and we'll write you in. But that's uncomfortable. It's not correct. We're not really doing anything, and it really is sort of a sham to really facilitate the payment of the commission by a principal who may be a technical, a Texas or an outside owner. So I think this is something that we really need to sort of figure out and talk about a little bit. I don't know if we need to do it today, but it's not an easy question. It's a complicated question.
Bill, are you talking about, is this mainly happening in commercial?
Yes.
Commercial?
Yep. And again, I'm not in the residential realm, although I imagine it could happen in residential if you're dealing with, there's probably, it probably doesn't, because I would imagine that there's already rules and stuff with regard to, national companies selling properties here and brokerage arrangements with referral sources and stuff already. But on commercial, it's really sort of the Wild West still, and there really is a lot of people doing stuff, and it's not being done improperly. When I say improperly, in a bad way or illegally, in terms of fraudulently, and in terms of fraud, creating a fraud against consumers or people. We're dealing with people that are trying to facilitate transactions. We just have to make sure that they're doing it, so that they're not considered an illegal transaction or an improper transaction.
I have another question for you, Bill, just because
Sure.
I'm not familiar with
Sure.
commercial at all. So when you're saying that the principal pays, so there's not a title company that issues the commissions?
Well, sure, but you're instructing the title company. The title company is paying on the instructions of the principals. I mean, title companies are just facilitators. They're not in the deal. They're just paying what people are telling them to pay.
But as of now, like, the commissions have to go to the brokers.
No.
Right? It's still, but in real estate, I mean,
Well,
in residential, it does. So it's
no,
not the same in commercial?
Well, I'm talking about from the principal. Principal can pay whoever they want to. And so if the principal is paying Joe from Alabama, they can do that. If a guy wants to pay Bill, if I'm let's say I'm in Texas, so I'm getting paid by the Texas guy, but let's say my client is from California, he can instruct me to get paid by him. I have a listing. I'm a Texas agent and broker, but a guy who's the agent from Michigan who's representing the seller of the property, he's getting paid, but he's getting paid by the seller of the property, who may be from California, maybe from Illinois, who knows where they're from. And so and they're facilitating the transaction. I mean, they're doing a lot of work. They're providing the due diligence. They're organizing stuff. Everybody is handling the transaction. And so it's not about the title company. Title companies are really just clearinghouses.
Mm-hmm. So I guess this goes back to your very first question to staff, like, is there any rule on the principal, or like, how do we kind of go around this based on the rules and the laws?
Well, and it seems like to me, though, that is the correct rule. A principal should be able to pay whoever they want to pay. It's not up to the state or to anybody to tell somebody who they should pay, if you're the guy who owns the property or is buying the property. So that, I think, is correct. The real question is the relationship between agents, outside agents and inside agents. I say outside the state and inside the state. And that's creating a little bit of a conflict, because it's creating a gray area. It's making it very difficult to, there's no clear line. And that's what I think is the biggest problem.
So Bill, what would be the danger of maintaining status quo? And what would you recommend to make sure we're protecting everybody like we're supposed to be?
It seems like the issue really is the prohibition from an outside agent or broker doing brokerage activities in the state. That seems like the biggest issue. And I really need to think this through. This is not an easy question. To me, it's hard to tell somebody not to facilitate a transaction. It's not about getting paid. There's two different things here. One's getting paid and one's facilitating the transaction. And that's, I think, the issue that we need to talk about, is what the requirements would be on facilitating a transaction. If you don't allow the outside guy to help do the deal, it puts a lot of pressure on the local broker to help do the transaction. In other words, I don't want to be the guy who's doing all the work and the other guy gets paid. He needs to do his stuff, and the stuff that he's doing is not rocket science. It's facilitating the transaction. It's not, it's not making the contract. It's not doing legal stuff. It's basically doing brokerage services, and brokerage services is very, very broad, I think. And I think that's the slippery slope we're in, is what's brokerage services.
Okay, I think what we'll do is, I know Bob has a comment. I don't know that this whole conversation is necessary for what we need to present to the commission. So we need to decide if we want to finish this today or at a different time, because since it's not necessary at the moment. I know Bob has something to say right now, though.
Okay, and I noticed Douglas O'Mixon on the call earlier. He may have left. If not, Tony may have some memory. We addressed this issue in the previous group, specifically dealing with commercial and the scenarios that we had. You're a commercial broker out of Chicago, and you're the national broker for a developer or a retail chain, and they want to do something in Dallas, and they look to you, and so you work something out. And so we look specifically at some type of a process for commercial, at that point, commercial only, to be able to work through the process, and that person be able to physically negotiate a transaction in Texas, because as Bill points out, they were doing it anyway. So let's go ahead and create a process. And it's really not the money situation, although that needs to be addressed. It's the service to the clients. It's making sure that you've got that broker who's coming to Houston or Dallas or wherever, and they understand Texas and they understand Texas law, and they can work through Texas situation. So I think at some point in time, we do need to address it. Clearly, it's not a principal issue. It's a brokerage issue. And I think this is one of those things that the ability of TREC to regulate, the ability of the staff to do something, needs to reflect what's best going on, best practices, what's actually going on in the real world, that we just can't ignore in some way, shape, or form, have to give the staff the tools to deal with it. And I think it'll be an important conversation we have at some point. Not necessarily now, but at some point.
Do all of you agree to table this until people?
Yeah, let's table it.
Together? Okay. So staff, do we have everything together that you need to present to the commission prior to January?
We do-ish. How's that? So let's look at under item 9. Leslie and I talked a little bit about this, and actually, Chance, you kind of mentioned it in your motion earlier. Leslie, if you want to take up item number 9, staff has a recommendation on that, which should answer your question on whether we have everything ready to go for the commission meeting. Do you want to do that?
So the next item is, or number 9 is discussion and possible recommendation regarding broker responsibility working group proposal to be presented to commission at their November 10th, 2020 meeting. The staff want to speak to this first?
Yeah, so what we would recommend, and having talked to Leslie about this, and I think you've also seen it come up a little bit in our conversations today, is you're going to have to, as a group, you have to bring your recommendations that you voted on to that November 10th meeting. So what you could do is delegate that responsibility to the chair to bring forward the proposals. She's already going to be bringing forward a report, and she can work with staff to make sure the proposals are clear and you get your message across without making any substantive deviations. So that would be staff's recommendations, to delegate that to the chair, who can take what you voted on and present it to the commission.
So moved.
A second. Or do we have to take a vote? Sorry.
Who seconded that, please?
Pam.
Thank you.
So Leslie, you could either do a roll call vote, or you can ask for all those abstaining, all those not in favor, and then if you have a unanimous vote, all those, then you'll know if you've got everyone. Or you can just do a roll call the way that we've been doing it. It's up to you.
Do a roll call, that may be easier.
Sure.
Okay, Bob?
Yes.
Chance?
Yes.
Soccer? Holly?
Yes.
Leslie? Did you say yes, Leslie?
Yes.
Yasmin?
Yes.
Bill?
Yes.
Brian?
Yes.
Pam?
Yes.
And I didn't hear Soccer. I don't know if she dropped off. Okay, well, we have everybody except Soccer. I think she might have dropped off the call. So it passes.
In chat.
Yes, correct. Okay, so it's unanimous.
Motion carries. I think we need to back up and go to public comments. We got 2 emails. One was regarding the proposed rules and contract changes to regulate flippers. I don't believe that's open for discussion, but I don't think there's anything we can do to that. I don't think flippers or investors can be regulated by TREC. So I don't know if y'all saw that email that was checked.
I didn't see, was there an email sent?
I think Amber's gonna pull it up right now.
Okay.
It just says, regarding the proposed rules and contract changes on the TREC, I would suggest all flippers/investors be required to hold a Texas real estate license in order to sell the rehab home.
I don't think that that's inside the purview of this group.
So yes, I don't think that's necessarily what we can do. And then there was one other email regarding licensing, and just saying that people think it's very easy to get licensed in Texas, and the quality of licensees is going down, which I think we've all discussed in previous meetings. Does anybody have any comments?
I don't think we have to make any, I think we've already addressed it, and I think we should just acknowledge the letter, and that's it. I mean, we've already addressed it.
Agreed.
The next item is discussion and possible action regarding future agenda items and meeting dates. It's been suggested that we meet after session, probably in February. And before that time, I was planning to meet with Chelsea and Scott Kessner about different topics that we've brought up in the past that we would like to discuss, and so maybe we can have some future guidance of where we need to go with this. I know we've talked about limited service companies, and that also came out in a town hall, and there were several other topics that we talked about right when we started in this group. Are you good with waiting until I meet with them to figure out how we're going to move forward and what topics we're going to address, or does anybody have any comments towards that as well?
Well, what's the longevity of this group? I mean, do we have a term? Is this sort of a working group, or do we just keep going, or what's our deadlines?
I think that's a great question. Yes, the intent is to do a little bit of a break in terms of let's let sessions start, right? Get going. We'll have that February meeting and then reconvene in February with Leslie having visited with Chelsea and the chair of the commission to talk about, what does the chair have interest in you guys covering? And then also, what do you guys have interest in covering? So we don't see this group as going away. And we'd like to get it, somewhat of a plan formulated for things that you guys can cover, so that one, you know what you're covering, and two, you know that it's something that there is a real interest in on behalf of the commission. So it kind of taking this break allows for a little bit of some planning and strategy as to how we take up the rest of the year, or I guess the new calendar year, but you know what I mean.
And what I may do as well is just send out an email to all of you kind of asking you, what are your top objectives? What are the things that are important to you? So maybe we can encompass all of those as well. I know we had a list at the beginning, but just to make sure that we kind of touch on the points all of you wanted to be involved in, things that you think need to be discussed.
Yeah, so we'll need to do that staff, I can do that, is ask you guys for input and recommendations just to respond directly to me. But we can get that out there. I just don't want to have an open meetings issue.
No. Talking about doing it as in a survey way that we've done it in the past.
Yeah. No. I know you meant that. I just want to make sure everyone knows. I get nervous anytime anybody says email, you guys. I'm a lawyer. But yeah, we can absolutely do that too, right? Recommended topics from you guys, and why you're here and what you wanted to talk about. So this gives us the time to get situated and planned so that in February we really are ready to roll on all of the new stuff.
Perfect. And does Wednesday, February 17th work for everyone? And we need to decide if mornings or afternoons are better. Because I know we were at 1 o'clock.
Personally, I like this first thing in the morning because it really sort of helps keep the day going.
Wednesday works for me.
Works for me.
I guess you're fine with Wednesday, 17th in the morning, 7 for everyone. Okay.
And Madam Chair, can I make a suggestion before our next meeting real quick? And this is in no way, shape, or form intended to detract from the expertise of the great and wise Bill Roth. But when everybody on this call is focused on residential and we have one person focused on commercial, you've got to make a big decision about commercial. It might benefit this group if we had a bit of a round table of some people who actually do commercial work, lending some expertise to that discussion.
No offense taken. In fact, I think it's a great recommendation, and maybe that could be one of our education or sort of, maybe we could do that, either having another person from, or another couple people in the group, but also maybe having a little training session or having bringing in some people as a resource to talk about it and ask questions and do it that way too. But absolutely, it's a great suggestion, and I appreciate your mentioning it.
I've also found it beneficial, and all of you probably could do this too, is going out and touching base with other people that are in the field that maybe do different things than you do, or maybe have different thoughts with you, and just send them questions over email. Go, what are your thoughts on this? What are your thoughts on that? And you get some really good answers to hear what people are really looking for.
You know, the other thing would be that, and I'm sort of tied in, and other people are tied into a lot of commercial groups. If we could sort of develop some particular issues that we want to get general survey information from, then I'd be happy to try to help access, you know, some of these groups to get some feedback to see what's going on if we have specific questions to ask for, especially from the commercial associations throughout the state, some of the trade associations that are doing commercial stuff. Certainly, there's a lot of folks out there that would be happy to weigh in if we have specific questions to try to get responses to.
I think it's also great to ask them maybe what are their hurdles and what would they like addressed by us.
I'll bring that up at the. I'm on the board of a couple commercial associations. I'll bring that up at their next meetings and see if I can generate any interest in weighing in on that.
So can I ask a question?
Sure.
Will you be sending out a little bit of a summary to all of us on what we've agreed to and what's going forward to track?
That's a Vanessa question.
Vanessa?
Yeah, we can. So we can. We'll definitely do minutes, right? And the minutes should summarize all of your recommendations that we've reached today. And I can put together a bit of a summary of where we landed and send it out to you guys. That's no problem.
So we would have it before the November track meeting.
Yes, yeah, we can get you something. Those minutes should go quickly, and if we need more than that, I can provide a summary. And you guys can always reach out to me directly if you have questions too. But yeah, we can take care of doing something like that for you.
Thank you.
Uh-huh.
Anything else? Okay, guys, I guess I'm not going to see you all until February.
Can I, Leslie? I wanted to give you credit for really you've been doing a terrific job in getting all this stuff together, and I'm not just stroking. I really think everybody appreciates all the hard work you're doing. You're really carrying a lot of water, as well as the staff. I mean, I know this is really complicated stuff, and it's the amount of paper. You get credit for all the paper that you generated, so that's great. Thank you for doing this.
Thank you. Well, I hope all of you have a wonderful holiday season. Hopefully in 2021, life will be a little bit easier and we will get to meet in person. So with that, it is 12:11 and this meeting is adjourned. Go out and have a great day. Thank you.
Thanks, everybody.
Thank you. Thank you.